this is partly allowed. That case will stay, but that she will not vacate the house.
Hello.
May I please, Your Honor? I beg to mention item number 7 for adjournment. Concern of the other side.
Learned counsel Miss
Embora.
Embora, with the consent of the other side, has prayed for adjournment. List the matter on after 2 weeks.
May I please, Your Lordship? Lordship, with the consent of the other side, I beg to mention item number 18, Lordship. Lordship, my senior Mr. S. Chavan is out of station. Kindly adjourn for the day, Lordship.
Learned counsel Miss
R. Dev.
R. Dev, on behalf of learned counsel Mr.
S. Chauhan.
S. Chauhan, representing the respondent,
Respondent.
has prayed for adjournment after taking the consent of the other side. List the matter after 2 weeks.
Lordship, only fixed date.
Dated at yes.
25th. April 4th April. Obliged.
My lord, in item number 8 and 9, I shall do the cases today. Only thing to reply with to be called from the department.
Sorry, I cannot hear.
Reply affidavit to be called from the branch.
Yes.
I'm giving the LD.
Item number 8 and 9.
Title.
This is for hearing orders.
Order. Yes, yes.
Learned counsel Mr.
NS Mazhavia.
And 8 and 9, no? NS Mazhavia has submitted that he will file affidavit in reply against the objection filed by the respondents
Today.
today.
Yeah.
So when do you want?
Today, it may be done or any other day. As your lordship may please.
No, you will file affidavit in reply today. So
Yes.
when will I fix for hearing?
Yes.
Pleadings are complete, no?
Yes.
Main case to sir. Okay, you file. Let it come for orders. Then we'll alright. List the matter after 2 weeks.
Yes.
Item number 15, my lord,
Hmm.
taken consent of the respondent, my lord. May it please, my lord, this matter may be taken up after 2 weeks or 3 weeks. my lord.
Learned
after the
counsel
written-
Mr. S.
S.
Count,
Count.
with the consent of the other side, has prayed for adjournment. List the matter after 3 weeks.
Yes, sir. After the case.
After
A date may be fixed otherwise.
list the matter after Bihu holidays.
24th April.
List the matter after ensuing Bihu holidays.
Wait, please, your lordship, lordship,
Hmm.
I beg to mention item 20, I've taken the consent of the other side.
And for the respondent.
Adjournment of 4
As
weeks.
agreed by the learned
After 4
counsel
weeks.
for both the sides, list the matter on
After 4 weeks, lordship.
after 4 weeks.
20.
Please,
Obliged.
I'm obliged.
Item number 2.
May I please, lordship?
Hmm.
Which consider NDPS.
NDPS, okay.
LCR.
Call for the scan, charge sheet at NDPS. Call for the scan copies of the trial court record along with the scan copies of the CD. List the matter on which thana?
Korimganj.
Korimganj. 25th March.
Obliged.
Item 3.
Make this is a lordship. Sir, offense registered under special act, trial is proceeding. Charged matter.
Hmm.
This LCR may be called for. It is from special judge Karimganj.
And POSCO Act, no?
No, madam,
No,
under
NDPS.
NDPS act. Yes,
NDPS.
Call for the scan copies of the trial court record along with the scan copies of the CD. List the matter on dated at the.
On 26 March.
ma'am. Madam, 27 can it be possible?
Yes, yes.
27.
Item 4.
Yes. Item 4, Manoj is in custody for last 2 years, 9 months. Earlier, he approached this honorable court and lordship was pleased to reject. Now, only 5 witnesses has been examined. So, in this case, also, what I am praying for that LCR maybe called for.
Call for the scanned copies of the trial court record along with the scanned copies of the CD list, their matter on date of the
28 March.
Yes, yes,
28
yes,
March.
28.
I'm deep looking. Item 5.
Thank you, Your Lordship.
Mm.
Yeah, please.
Hmm.
Alert, on the last provision, you have put that matter. Second appeal.
Oh, second appeal,
Yes.
substantial questions of
Yes, yes, yes. That I am the plaintiff in this suit.
Sorry,
I am the plaintiff in this suit.
okay, okay, you have,
Yes, suit for my lord, declarations and for permanent injunction.
mm,
I have lost in both the courts below. Now, Lord, you will find the substantial question of law. I have formulated that page 4, B, C, and D. Lordship,
mm.
main issue is here that I have pleaded.
Why did I fix it today for us?
Yes, for that.
Oh.
Your lordship said that we'll go for the record.
I'll go
Record has
straight-
not called for.
No, we'll go for record of this case.
Hmm.
Because what has happened, he has taken a completely new plea. A new plea, he has not pleaded, he has not taken the plea in the plain, in the memo appeal, and in the second appeal, he has taken a new plea. It is part of the, may I speak, please?
No. I am the appellant, so I have to, I have to satisfy because whether there is a substantial question of law or involved or not. But my learned friend is arguing on the last occasion also, I have not given any opportunity to argue.
No, you have argued.
Then-
At that time, just you shall say.
Lordship, the main issue herein is that I have prayed not to disturb my possessions without following due process of law. Now, Lordship will find page 12 of my memo of appeal. This is the plain and prayer portion.
Hmm.
If Lordship permits me, my Lord, I will read. Should be decreed declaring that the page 12.
Just a moment.
Yes.
I have noted down some, your submissions. I'll
Yes.
just go through it.
Yes.
Please sit down, please sit down. I have noted down your submissions. I'll just go through it. Yeah, last time I have noted down the submissions. I'll just go through it.
Discarded for.
Yes, I got your point now. Mm.
Lordship will find page 12 of my memo about it. Prayer in the my lord plain.
Page
12.
12.
May I read?
Yes.
That if plaintiff therefore prays that it should be decreed declaring that the plaintiffs have long possessions of artist woodland and their possessions cannot be disturbed or taken away by the defendants number 1, 2, 3, 4 by taking law into their own hands. Should be decreed declaring that the plaintiffs' long-standing possessions of this woodland cannot be disturbed. They cannot be forcefully dispossessed except under the due process of law. The plaintiff's possessions of the woodland be confirmed. Now I will skip that part. Now Lordship will find page 32. It is the before that Lordship will find page 17. Before that, page 17 of the part of the WS.
Yes.
Filed by the defendant number 1, 2, and 3. Lordship will find paragraph 11. That the statements, averments, allegations made in paragraph 3 of the plaintiff are completely false, frivolous, and concocted. That it is denied that the plaintiffs have been possessing this woodland as before. That the plaintiffs are simply a heir of the opposite party defendant number 1 for just only 3 years. Lordship may kindly mark that. Who used to do only seasonal cultivations of petty crop and also gave 2/3 share of petty
Yes,
crop.
that day you have argued this,
Yes,
yes.
that part I will come. Now Lordship will find page 32,
Page 32.
my lord. It is the part of the trial for judgment. Page 32.
Yes.
In the my lord, page 32, last paragraph. Starts at in order to. Lordship got it.
Yes.
In order to prove their claim, the plaintiff number 1 adduced his own evidence on affidavit and exhibited certain documents. It is settled law that the initial burden always lays upon the plaintiff to prove his own case, and therefore now let us discuss whether the plaintiffs have been able to discharge their burden. PW1 in his evidence on affidavit has reiterated the statements made in the plaint. Further stated that, Lordship kindly mark that part. Further stated that the defendants have admitted in their written statement that the plaintiffs are in possession of the woodland as adhere, and therefore they cannot be evicted from the woodland without following the due procedure of law. My lord, that part of the my lord, the plea of the my lord, plaintiff has not been considered because since in the WS the defendant number 1 to 3 has admitted that I am the adhere of the woodland. Therefore, I cannot be evicted without following due process of law. That is my prayer in the plain. So
this is one substantial question of
yes,
law.
that's why the Assam Temporary Settled Areas Tenancy Act 1972
Yes, yes.
protection.
Let me see. Yeah.
Yes, protections provided because I am the non-occupancy tenant. Adhere is my lord comes under non-occupancy tenant.
You have taken back the book that day, no?
Yes,
Let
because
me see.
on the next date, not on that date, on the next date I have taken. I will give that book.
Okay.
So my first substantial questions of law, the protections provided because my pleading is clearly shows that I
Under section?
under sections 15 and the procedures for ejectment is provided in 51. It's provided that a non-occupancy tenant shall have right of possession till he is lawfully ejected and subject to the other provisions of the act or any customs of the tenancy shall dissense in.
Yes, yes, I got your point. I got your
Yes.
point. Now I got your point.
Yes.
So there was a long argument relating to permissive possession.
No. I am
oral-
not on that permissive.
Oral
position.
agreement and all.
My only submissions is that my pleading in the plain as
Yeah,
well as
you are adhere, so you have to evict.
we
But according to him, you are
have
adhere
not
for
filed any counterclaim.
no for 3 years only.
Yes, it is provided 3 years.
You are adhere for 3 years only.
Yes.
Okay.
Even
Alright.
since they have admitted that I am the adhere, so I am entitled the protections provided under the Assam. That they have not filed any fresh suit or they have not filed any counterclaim. So my only submission is that the protection.
Where is this question of law, in which part of your,
C.
oh, C, okay.
Yeah.
No fresh suit or
Counterclaim.
counterclaim. Okay,
Now this another substantial question of law, in the both the courts below have clearly held that the defendants have denied the execution of Exhibit 10. That is an affidavit executed by the defendant.
no, this won't come. Because this exhibit 10,
Yes,
it was not proved by the people who have given their
that is
signatures.
the perverse finding, my lord. That is because the in the cross examinations of DW1,
Hmm.
yes,
No, now I'll not go into cross-examination.
because the records is necessary. Otherwise, how will I prove? Because the record, if lordship, this is the certified copy, if lordship peruse that part also.
See, you see, later, at a later stage, another substantial question of law can be added, later stage. And you see, it's not necessary that you have to decide on that point only. We can decide the appeal
And
on
lordship, that
additional points also.
in the order,
So,
lordship,
but now you see that exhibit 10 won't work.
then
One, you have only one substantial question of law.
then lordship will make an observation that if any other substantial questions of law will be framed at the time of hearing, that observation may be recorded in the order.
Let's see. Let me hear the other side.
Okay.
Substantial question of law C.
C, that is in respect of the.
So I think he has one substantial question of law. Let us frame it.
Before that, only one submission.
So see, I'm not,
No, no.
I have heard you,
Page
this case is totally on your submission only.
Page 56.
I have decided this point totally on your submission only. What else you want to
I'm
submit?
request only please page 56.
Uh,
The suit is for not to reason possession, permission for possession.
Permissive.
His case is that, and he should not be evicted without the process.
No,
Page 56, they have filed a petition before the appellate court, page 56. Only one.
okay. Page 56.
Mm. 13, discussion, decision, reason thereof. We shall first decide petition number so and so, by which prayer for dismissing the title.
Where?
Okay.
Which paragraph? Page 56.
13. We shall first decide petition number 383/24 by which prayer for dismissing the title level number so and so on withdrawal with opportunity to further withdraw.
That was decided.
Yeah,
Already they have stated that we are evicted. Now what remains, your lordship, because
Where he has stated he was evicted.
he was evicted in the
When?
he will file a petition.
When they have evicted, that lordship will find page 58.
This is my turn. I mean, from the pair 14. From the
Paragraph 14,
pair
yes.
From the pair person of petition number 380/23, it is clear that 20 wants to restart the title suit at this appellate state. Payus order 23/20 of CPC. Please deal with withdrawal of suit. Court of civil procedure by Sarkar, even addition, so deals with the matter. We stated grant of leave emphasized in Sub-Rule 322 is a decision of the court to be exercised by the court with caution and supposition. Clause B of Sub-Rule 3 contains the mandate to court that it must be satisfied about sufficiency of the grounds for allowing the plaintiff to issue the fresh suit for the same claim or part of claim on the same cause of action. This becomes all more important in a case where the plaintiff has the application order 23 Rule 1 at the stage of appeal. Grant of leave in such a case will result in unsuccessful plaintiff to avoid the decree against him and seek a fresh education for controversy on a clean state. It may also result in a contesting defendant losing of the controversy on a clean state. It may result in the contesting defendant losing the advantage of education of the dispute by the court of courts below. Grant of permission for withdrawal suit with leave to file a fresh suit may also result in annulment vested in the defendant or even a third party. However, it is having held in so and so that withdrawal of a suit can be permissible even by the appellate court. We have discussed the laws on the matter of withdrawal of the suit. Now let us go to the grounds on which the pair for withdrawal of suit with permission to file fresh suit has been made. there is specifically there are three grounds: non-gender of necessary party, defective description of the area of the shootland, forceful occupation of the shootland by the opposite party. In para 2 of petition number so and so, it has been clearly stated that the patadar of the shootland is a joint pot holders and number of co-potters are 85 for a land covering 28 because 19 acres. But thereafter, it has been stated that 85 numbers of co-potters has got respective share of their land from lawful partition, and so the co-potters are necessary party. When the appellant plaintiff is stating that the joint potters have partitioned the land, the plaintiff has burden to prove that partition of land has been made, and other co-potters are not necessary parties. On the contrary, if partition was not made, the plaintiff in the original suit was bound to make them as a parties. But he has not done so. Therefore, the assertion of the appellant plaintiff, the co-potters are necessary party on that one hand, and they have partitioned their land on the other hand, are rival assertion which does not coincide. Therefore, the assertion of the plaintiff is not reasonable. Hence, first pair cannot be granted. The second ground for it is the defective description of area of the land. In para 3 of the petition number so and so, it has been stated that the shoot land during schedule below by mistake mentioned 2 vika or 0 lesser. It is an arithmetical mistake getting as a formal defect to the suit of the applicant. But in the schedule of the petition number so and so, again plot of land measuring 2 vika was provided, which is similar to the schedule of the plane. Therefore, plaintiff has failed to tell any variance and has specified the land as 2 vikas everywhere. Therefore, the assertion of plaintiff side are not true. Appellant petitioner in para 5 told the defendants forcefully enter the suit land on 12/6/2023 after dismissal of the suit by the land by the land trial court. Therefore, this is an occurrence after the judgment passed by the land trial court, and therefore the petitioner not entitled to rectify the claim, which has been filed for prior occurrence. Thus, we see the grounds specified in petition number so and so are unclear, vague, untrue, apart from being unreasonable. Thus, it's clear the petition has been filed only with the intention to delay the fruit of the decree to the holder by seeking a fresh education. Hence, Paris petition is rejected. Coming back to we find that the claim was filed with the following pillars. Should be declaring that the plaintiff have long possession of land and their possession cannot be disturbed or taken away by defendant by taking laws into opponents. Should be declaring that plaintiff long standing possession of land cannot be disturbed and they cannot be forcibly disposed except under the basis of law. The plaintiff possession of land be confirmed. Permanent injunction be decreed by restraining the defendant 1, 2, 3 from enjoyment and agent from entering land and from disturbing any matter the plaintiff's possession of the same. And all causes should be decreed. Any other alleged to be the plaintiff may found to be under law and equity also be decreed. From the pair, it is clear that plaintiff is seeking for possession of land on the basis of long-standing possession. Plaintiff in para 5 of plaintiff told that the defendants went to the subland and threatened him by utterance that they would forcibly occupy and cultivate the subland. Thus, it is clear that plaintiff was asserting that he was in possession of the subland. Such being the asserted state of affairs, the plaintiff could have filed under section 6.
Yes, yes, that day you
That
read
day.
this one, this part.
What? Because their suit has become impossible. They are not in possession of the land as per their admission petition filed by them. So if the honor admit what remains? They
When?
file a case suit for
No.
recovery because now the suit has been infectious.
How it become-
And
Yeah, continuous process.
both the lower courts have been finding that
Let me see that, evicted under the due process of law. Let me see your act,
Yes.
that book.
and they have to prove the poison. They have failed to prove the poison. Both the courts.
No, that judgment relating to permissive possession is known to all. Permissive possession cannot be changed to adverse possession. It's known to all.
This is a question of facts.
Hmm.
Can we interpret in the second appeal? This is my humble submission. And they have in their evidence they have not given a single.
No, that
Khatiyan.
we are not taking that into consideration. Only one law point.
We are competent. This will be given Khatiyan. I brought a judgment.
No, we are not bringing facts. Not
51.
bringing facts.
So
Lordship will find
Only
section-
one question of law.
because to be a
section 51.
adhiyar, he should have a Khatiyan.
There is admission. That's why.
Khatiyan.
No, Khatiyan is different, Adhiyar is different.
For 3 years, one long, 20 years back. Now the plaintiff, the defendant, 120 years cultivating the land, they are owners. So, with 20 years ago, in my land, one is the Adhiyar, always will be controlling the possessing the land. After 2-3 years, the landlord has said that you no need to cultivate the land. I will cultivate by myself. After the time, for such long as I'm cultivating. And this
This
is
is
observed,
Adia's
observed by the trial court and the appellate court. This is a pure question of fact, not law, your lordship. This is only a question of fact, not law. And this, in this regard, I have brought two judgment. And about disputed question of fact, it- the plaintiff is not in possession of land.
No,
Is
Lordship,
finding out.
whether
finding
disputed
out-
questions of fact, it is not
Both-
before the
both
second appeal.
appeals.
Second appeal is only whether the substantial question of law is involved or not. Because the learned courts below have considered the case of the plaintiff or not, that is the issue to be decided. Not the disputed questions of fact, everything will, because both the courts below has already discussed. My only submission is whether the learned courts below has considered that part, whether I am entitled the protections under the Assam Temporary Settled Areas Tenancy Act or not. This is the issue. Nothing more than
I
that.
think issue can be framed or this substantial question of law,
Because
only
he is
one,
not-
one.
He is not in possession. Second,
And
both
that
he, as per his, he want
What
to-
consequence I will
he-
get, that
he-
will
he-
be
he want to
decided
withdraw
later
the
on.
case
But
because
I have a
not the
right.
necessary party. He-
I have a right.
He will want to withdraw the case because he has not given a proper schedule. He want to withdraw the case because he is not passing.
That is not my substantial question of law herein.
What remains in this case?
We'll fix it for hearing, so we'll dispose it.
Yes, that's-
At the earliest.
One is fixed, it will take another 10 years.
Lordship may be
10 years.
accepted any
Because
day.
it is this case, because
After
what
record.
is a concurrent finding, your lordship. Your lordship, see. that he-
RSA is always on concurrent findings
not
only,
always, not always.
usually.
When to interfere. The lordship, see, this argument, three judgments. This one is this.
No, see, this is not question of fact. I'm telling you why this is not a question of fact. This case rests on this story that he has been allowed to cultivate. This is the main story.
No plea was taken in the plane.
What page 32 says?
No, not in the memo appeal also. In the memo of the memo appeal. In the second appeal, they have he is taken. This cannot be taken. I brought his judgment.
What page
It is
32
from the
says of the
program.
trial court judgment?
No plea can be taken in the second appeal. He have not taken the plea in the plain in the memo appeal. Now
Yes.
in the second appeal, he cannot take. This is
What,
the law.
what plea, what plea?
That he is the
Permissive possessor.
he is the adhyar.
This is the admission. What plea I can
He is
take?
the adhyar means adhyar.
The admission on the part of the defendant, what I can say? What my learned friend is submitting?
Now he's not adhere. 3 years ago he was adhere, not recorded adhere. So, not new plea cannot be taken.
What no
In
new
the
plea?
second appeal.
Application is there, what
High
new
court
plea?
judgment is there. Divisional judgment, Supreme judgment is there.
See, he has a point why I'm saying you'll have to mention it in your pleadings.
My lord, when there is a
When it has surfaced to the evidence,
page
that is not
32,
sufficient.
page 32 is it has been already recorded by the trial court, but that has not given any answer. Page 32
No,
says-
that has come to evidence. You
Yes,
cannot depart,
because-
evidence cannot be a departure from pleadings.
Since after filing plain, they have filed WS. In WS, they have admitted that I am the idea. So it will be obviously, my lord, I can bring it on the evidence also. Because
No, but
there
you have not mentioned it in the pleadings that you are a
is-
RDR. Permissive, only permissive possession.
No,
you have
no, no, no,
stated.
no. Because I have filed plain, thereafter they have filed WS, wherein they have admitted that I am the idea. What remains?
In WS.
Yes, in WS.
Development only for 3
Page-
years.
We have mentioned the WS. that
Yes,
they were
page
RDR.
17,
In the-
page 17, paragraph 11.
In the
That's why I have
For
pointed
3
out that
years.
part.
For 3 years.
Page 17.
Yes, WS starts at page 15. Lordship might
Oh,
kindly.
yes, yes, this is the WS. I thought this is the evidence.
No, 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 no. This
This
is
is the
WS, page
WS.
15. What remains?
Okay, let us frame the question.
This paragraph 7 and 8. The law will be clear. This is yes. This husband, yes. This Satish Chandra Prokayat, Santosh Kumar Prokayat, Supreme Court, AI 97 Supreme Court 2517, paragraph 7 and 8. I have marked it.
See, to your pleadings, he has stated that there was no reply or not a trace counter that you have not been evicted, you have not taken the plea
Which part?
to the WS. There was no reply from you.
My lord, in this civil suit, there is no any proceedings to file any reply
No, fresh. You have not brought a fresh suit also.
because I have a existing suit. I have an existing suit. That's why my lord, admission part on the part of the defendant has not been considered by both the courts below. This is my only prayer.
Yes,
No. What he has said is that you tried to withdraw the suit and then you wanted to reply to that you were an ADR. You tried to withdraw the suit.
Reply is not necessary in the suit.
No, not reply.
Yes.
To bring the pleadings that you were an ADR. You tried to
That's
withdraw
why
the suit.
that's why I have brought it in my evidence. So that is the page 32. The trial court recorded that part, but that has not been considered. That has not been
in
considered.
the memo also, no plea taken. In the memo appeal, no plea taken.
Memo of appeal, no plea taken. I don't
In
understand.
the appeal also, the first appeal, no plea taken.
How it is prevented,
No,
whether it is prevented or
It's not
not.
required. In the
it is
first
not
appeal, it is not required.
What plea should be taken because I think the judgment, page para 7 and please mark it. The lordship, please see one line.
Which one?
This one.
Now you are confusing me.
So,
Which one?
I
I was thinking in a proper order and now I'm getting confused.
Para 7 and 8. Satish Chandra Purkayat. 2000 AI 97 Supreme Court 2517.
Para 8.
Para 7 and 8. 7. I have marked.
Yes, please read it.
Para 7.
Hmm.
Delivering the judgment of two member bench in Fasugopal Borua and others versus Umesh Chandra Goswami in his judgment dated so and so, as briefly explained the scope of 100 does. A bare look at section 100 CPC shows that the jurisdiction of the High Court to enter the second appeal after the is confined only to first appeals as involves a certain question of law, specifically set out in a memorandum of appeal and formulated by the High Court. Of course, the proviso to the section shows that nothing shall be deemed to have taken abridged the power to hear for reasons to be recorded. The appeal on any substantive of law not formulated by it. If the court is satisfied that the case involves such a question, the proviso presupposes that the court shall indicate in its order the question of law which is proposed to be decided, even if such a law was not formulated by it. The example of such a question of law is thus Senate 1 for effects of the is under the amended provision of section 100 of CPC. Generally speaking, appellant is not to be allowed to set up a new case in second appeal or raise a new issue other than a jurisdictional one, not supported by the pleadings or evidence.
But it is there in the pleadings and evidence.
Yes.
It is there. You are an ADR. He is an ADR. It is
Yes.
there in the pleadings and evidence.
Or
In your WS and in your
or
cross-examination.
evidence on record, and unless the appeal is about such a law, or evidence on the record. And after that I am coming. In the present case, no such question of law was formulated in the memorandum of appeal in the High Court, and grounds 6 and 7 in the memorandum of second appeal. Only which in the present case, no such question of law was formulated in the memorandum of appeal in the High Court, meaning the first appeal. And grounds 6 and 7 in the memorandum of second appeal only.
No, let us frame this question. Only one question. Only
You
one
see
question.
that only they are not in position now. They filed a petition. This
That you are confusing me about the withdrawal of that appeal, huh?
That is not my.
I'm getting confused now.
That is not my substance.
no, there should have become an influxus. Your lordship may see.
I'll just frame only one question and I'll fix a short date. We'll hear it and dispose it.
Might.
The parties won't be affected. If you want to take over possession, you will take
I'm
it
in
over.
position.
Hmm?
I'm in position.
You are in possession.
I'm,
okay.
I'm the owner of the land.
So then where is the problem? Let us,
I'm the owner of the land. They are only permission for possessor. They have not also not asserted that they were in they are claiming for advance position. They only only position. I'm the owner. I have the right of the interest.
all has been decided in the appeal. No adverse possession, no permissive possession, nothing.
Yes.
So he is coming with ADR now,
And
and
Adhyar,
which has been included through WS. It is not that a foreign something
The
foreign has
WS
been
is-
brought in.
many years ago, long
Only
upon a time,
one,
long
only
upon a
one.
time, he was the Adhyar. Long upon a
Yeah,
time,
long
not now.
ago, yes.
After that, the court has come to a
But
finding.
he has brought a this law that you have to be evicted. So we'll just raise the question and we'll dispose it of soon. Chandrakar Kolita, you have submitted.
Yes, yes.
This is not required.
And about the Adhyar point also, I have said one thing. Adhyar, that the plaintiff is to prove about Adhyar in their case. This Chandrakar Kolita, pair number 20. This is this is
I understand that plaintiff must bring his own case and not rely on the
no,
witness,
not that point.
weakness of the
No,
defense.
not the case.
Chandrakanta Kolita.
No, this is, yes, yes. Considering the submission of pair 20, considering the submission of both the land council, it is very much surprising that both the courts below came to a conclusion that their defendant is the air occupancy tenant, and that too under Assam Temples Act 1971. When there is not even an iota of evidence in support of Khatian issued by the competent authority in favor of the defendant number 3 or defendant number 2, the status of occupancy tenant, the declaration of the status of occupancy tenant, and his entitlement to claim the benefit under Assam Urban Areas, Assam Temporary Civil Areas Act 1971 is well within the ambit and scope of the civil code to decide, but the same must be proved as per the requisite qualification stipulated in the said tenancy act 1971 for a person to fall under the category of occupancy tenant. The defendant applicant never even placed with regard to the rent, the nature of the position of defendant number 2 and 3. A mere carrying
No,
out
no, 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 no. He has stated that he has been paying the rent. He has stated in his evidence.
No iota of evidence, no iota of evidence has been given by the plaintiff, because for rent he has
There
to-
is no evidence
No
about
evidence,
paying
no-
the rent.
no evidence. No evidence.
But in this appeal memo, there is something mentioned
But
about paying the rent.
there is no evidence. And in the Khatian, there is no recorded by competent authority. In a said, no even pleaded with regard to rent. The nature of
In the plaint, he has not
no,
mentioned
no.
that he has been
No,
paying
no,
the rent.
No.
My lord,
No.
when I have filed another, my lord, I am submitting that. When I have filed plain, my lord, thereafter they have admitted that I am there. So that's why I have brought it in my evidence.
My case is that long before 20 years ago.
20 years, 30 years, it
Once
does not matter.
upon a time.
Because they have admitted in WS.
It a person
So
30
the
years
case-
ago, 40
Case
years
has
ago.
come in new terms. That's why.
This is the law. Para 20.
Just a moment. This Chandrakanta Kolita you have submitted, no?
Yes. The defendant never pleaded married. We got to rent. The nature of position
And then
of
Gurudev Kaur,
me.
I don't want this, not now at this stage. Then Gurudev Kaur, 2 judgments are not required, I think so.
Married. The defendant applicant never ever pleaded with regard to rent. The nature of the position of defendant number 2 and 3. And mere carrying out cultivation of for more than 3 years, and that too without any recognition of revenue authorities to any of the defendant number 3 as a
You're reading Chandrakanta Kolita.
yes.
I have read it.
There cannot be applicable tenancy act. It is finding of the High Court. Mere cultivating is not a there is no police side of the tenancy act. So this here on the facts of the case, plaintiff has not
Kitish Chandra Purkai, you have given.
Sandokal have given.
And Kitish,
Yes,
Kitish Chandra Purkai.
yes, I have given.
Okay, I'll ponder over it. I'll pass an order in the evening.
Mass supplies.
Oblige. I'll collect the book later on.
Okay. না এখন থাক মার্ক করে থৈ দিছে ন তো দি দিবাচোন
Please, a lot. I say to entire my lord,
Oblige.
I have appeared for item number 8 and 9 when my friend is there. I am respondent, my lord. My lord, in the last order, my lord, it was specifically mentioned in the order that in several locations, my lord, they have in some option taken time without consent of the respondent. And
8 and 9
8 and 9, my lord. Today also, my lord. Today also.
something was submitted I forgot
submitted, my lord.
Oh, affidavit in
My lord, they
reply.
have filed an amendment petition at this stage, my lord, second appeal stage, my lord. The first appeal was filed after 3 years of the judgment, my lord, trial court. And the trial court, my lord, dismissed the appeal on the ground of delay, my lord. Against delay, the second appeal is filed, my lord. And again, my lord, in several occasions, my lord, they are delaying the, my lord, matter, my lord. And lastly, my lord, they filed an amendment petition, my lord. There is nothing, my lord, devoid of merit, the amendment petition, my lord. We have filed an objection, my lord. Where is the provision of filing another reply of the objection, my lord? So just to delay, my lord, they have mentioned at my lord, 10:30, my lord, without informing us, my lord, the matter, my lord. So my humble submission, my lord, the matter may be, my lord, taken up after 1 week, and my lord, for orders column, my lord. It is
1 week likha ase,
IA
2 weeks likha ase na?
IA, my lord, for
Okay, we can give a date on
of
date also. Next date ka dijiye next week ot. Eric koriba, Gita thak koriba. Yes.
it will come
Yeah,
for,
we're giving a date, huh? Your senior came.
yes, my lord, it will come for orders, my lord. I think it is mentioned for hearing, but it will come for order because IA is there, my lord, for amendment.
In the
So-
orders column bolu likhi dibol dibason. In the orders column aru heri positively eta word insert kodibol di diba. Okay.
Public.
Date to dila.
Item 6. This civil revision petition has been filed, Your Honor, challenging the With your lordships kindly taken up the matter of civil revision petition, Your Honor.
Civil division petition.
630. A small issue, Your Honor. There is a three IAs.
360.
Yes, 360.
Hmm.
There's 3 IAs has been filed for in between the civil revision petition. One of the respondent has been expired. For his substitution in the legal hairs, this IA has been filed, Your Honor.
Which one?
3686
3686. Yes.
and
Hmm.
and another one for substitution for 3687 and 3688. There are
Hmm.
3 IAs.
Hmm.
But the thing is that 360 is the main CRP, Honor.
Hmm.
In this case, we have challenged the order dated passed by the Narada Civil Judge Kamrup at Amingaon 27/5/15, and it's page 47. But record has not been called for in this case also.
Yes, page 47. Yes.
May I read the order, Yana?
Hmm.
Both sides are present. By this order, I shall dispose of the petition.
What about the IS for?
IAs are still pending. If you taken up the IAs, Your Honor,
Well, if I said before that,
Hmm.
already last occasion on last day, it is this case of before this order before.
Hmm.
Things is that first thing is that
Hmm.
revision petition is maintainable or not.
Hmm.
Then I will come. Because IA is filed in the year 2019.
Hmm.
In the year 2019, the revision petition filed 2015, they got the stay order. He is enjoying last 10 years. What is the IA? What is the revision petition? What order has been challenged? What order has been challenged?
Hmm.
He said that page 47
Hmm.
is the interim order.
Hmm.
What is the order? I read it on the last occasion also.
Hmm. What is it?
That order,
Hmm.
without filing the delay coordination petition,
Hmm.
they filed a substitution petition. Already in this case, already substituted in the year 2006.
Hmm.
It is the stage of appellate stage. They have lost their case in the trial court because it is a partition case.
no, you have to. If
Then-
your thing has to be
then you
clear
have
from
a
right.
lot of things. First thing is that today, my lord, not for that substitution petition delay application
Hmm.
because they filed this CRP against the dead person because they, if it is a delay 4,000 years, 4,000 days, how many years? How many years they filed in CRP 2015? They filed a delay application or substitution petition or abatement in the year 2019. If it is delay, supposing to me is 4,700 something days, then it is the year of 2012 because against the dead person knowingly filed this CRP and took the
the order.
Entire thing has to be.
Wait for some time.
Who is the deceased in this
Lordship,
Myself,
petition?
I'm the I'm the legal heirs of the
Okay.
opposite party number one. Defendant, that is the chief.
Bhubaneswar Boro.
No.
No, we are the three son. That is Bhubaneswar Boro, Jiten Boro, and Ratneswar Boro are the son of late Tonkeshwar Boro.
No, Thekara Boro. You are a
Thekara
son,
Boro,
you are a
Thekara
son of Thekara. I have to
Thekara
explain everything. If your lordship allow me to submit my petitions, I have to enter thing and to clear whether law is applicable under 22 rule 4 and 10A, new edit. The thing has to be come up. I have to explain everything on. Now, if you go to the 47 or implement order to the 47, page 47, may I read the order? Both sides are present. By this order, I shall dispose of the petition filed by the appellant under order 22 rule 4, reduce section 151. It is important 151 CPC, praying for allowing to substitute the legal representative of late Thekara Boro. In the suit, the Thekara Boro was the defendant respondent number 1, and his 3 sons has been implicated in the main suit, in earlier suit. Now, I have already heard the submission placed by the learned counsel of both sides. The case of the appellants are that they have filed an instant appeal against your lordship. There some appeal has been pending before the learned civil judge Kamrup Aminggaon. They have filed an instant appeal against the respondent being aggrieved by the judgment and decree passed by the learned Munsifa Rangia in connection with title suit number 11/06, and accordingly the instant appeal is pending for dismissal before this court. It is stated by the appellants that the advocates for the respondent on 11/6/2024 filed 2 documents. That is important. 2 documents before this court. One death certificate in respect of Thekara Boro, that is respondent number 1, and other is the list of family members of Thekara Boro, and accordingly this court was pleased to pass an order on 11/6/2014 directing the appellants to take steps to substitute the names of the legal heirs of late Thekara Boro. That is the respondent defendant number 1. It is claimed that, by the appellants that only on 12/6/2014, the death of Thekara Boro came to the knowledge as the same was informed to them by the learned engaged advocate. That is the petition that Thekara Boro's counsel, engaged counsel, submitted before the learned court below. Then the appellant came to know that he has been expired. It is also stated by the appellant's petitioner that out of 13 members of family members in respect of Thekara Boro, respondent number 1, Bhubaneswar Boro, so and so, of the list submitted by the respondent 1, Ratneswar Boro, serial number 3, Jiten Boro, serial number 7, submitted have already been impeded. They were already impeded. They are already heirs of the Thekara Boro. As the respondent number 2, 4, and 3 are respectively in the instant appeal. However, right to sue still survives against the legal representative of Thekara Boro. So the remaining family members of the Thekara Boro, as shown in the list submitted by the respondent's side on 11/6/2014, are required to be impeded, substituted as a party respondent in place of Thekara Boro, and that the following persons mentioned in the list submitted by the respondent are required to be submitted. They are Binita Boro, Lakshmi Boro, Dharmen Boro, Pratima Boro, Gita Boro, Sita Boro, Birju Boro, and Rita Boro, and Ashim Boro, and Thankfu Boro. Hence these petitions. To this effect, the respondent submitted a written objection. The respondent number 1, that is Bhubaneswar Boro, has submitted his objection. Other have not submitted their objection. Wherein they contended that the petition filed by the appellant petitioner for substitution of the legal heirs of the deceased Thekara Boro is barred by the law of limitations. As appellants have not filed a petition within the period of limitation, it is claimed by the respondent that deceased Thekara Boro died on 26/9/2013 at his own home at village Korora Gorbitor, and an appellant whose house is situated just opposite to the Thekara Boro attended the funeral and other religious rites of the deceased Thekara Boro, as such willfully aware of the death of the Thekara Boro. Therefore, the claim of the appellants, they have came to the know about the death of the Thekara from the petitions filed by the respondents informed the death of Thekara Boro is absolutely fraud and baseless. It is further claimed by the respondent that the petitioner have not filed any petition for condonation of delay in filing the substitution of petition, which is mandatory as such. The petition filed under Order 22 Rule 4 of the CPC is not maintainable at this stage. It is claimed by the respondents that as regards the name of the legal heirs of the petitioners have wrongly given the names of Binita Boro, so and so, so and so, so and so. Upon the above considerations, the respondents prays for dismissal of the instance petitions and filed by the petitions appellants. Now the observations. Here in the instance suit, the respondents number 1 Thakuraboro died 26/9/2013, and under Article 120's Limitation Act, the period of limitation for substitution of legal hires of disease is 90 days from the date of death. And if party fails to file a petition for substitution of legal hires of the disease within the limitation period, then the Article 121 Limitation Act and the period of limitation is limitation for setting aside and abatement is 60 days. It is an admitted position that after the expiry of 90 days from the date of the death of the disease, and if no steps are taken for the substitution of a legal representative of the disease, then the case against the disease automatically abates. But the instance case that said Thakuraboro died 10 months prior to the lodging of the instant petition, that is under Order 22 Rule 4 151 CPC by the plaintiff appellants. But surprisingly, along with the instant petition, no petition for the filed by the petitioner under Section 5 of limitation for condonation of delay in filing the instant petition.
Okay.
Now, may I go to the entire provision of the Order 22 Rule 4, more particularly Rule 10 of the CPC.
Okay.
What is a law required in this case? Order 22 is the death, marriage, and insolvency of parties. Rule 4 says procedure in case of death of one of the several defendants or of sole defendant, where one or two or more defendants dies and the right to sue survive does not survive against the surviving defendants, the defendants alone, or a sole defendant or a sole surviving defendant dies, the right to sue survives, the court on his application made in their behalf shall cause the legal representative of the deceased defendant to be made a party and shall proceed with the suit. Any person so made a party make any defense appropriate to his character as legal representative of the deceased defendant. Number 3, whether within the time limited by law, no application is made under the sub-rule 1, the suit shall abate as against the deceased defendant. Number 4, the court, whenever it thinks fit, may exempt the plaintiff from the necessity of substituting the legal representative of any defendant who has failed to file a written statement or who have filed it but failed to appear and contest the suit at the hearing. That the judgment may in such case be pronounced against the said defendant notwithstanding the death of such defendant, and shall have the same force and effect as it has been pronounced before the death took place. Number 5, it is important, where the plaintiff was ignorant of the death of the defendant and could not for that reason make application for substitution of legal representative of the defendant under the schedule within the period of specified in the Limitation Act, and a suit has in consequences abate, and B, the plaintiff applies after the expiry of the period specified thereof the Limitation Act for setting aside the abatement, also the admission of that application under Section 5 of the Act, and on the ground that he had by reason of such ignorance sufficient cause for not making the application within the period of in this act, the court shall consider it. Now, the most important is the Rule 10A. It has been subsequently been amended. A new rule has been placed. Prior to that, Rule 9 is also the effect of amendment dismissal. Now, Rule 10A, duty of the pleader to communicate to the court death of a party. It is mandatory. Whenever a pleader appearing for a party to the suit comes to know that the death of that party, he shall, it is mandatory, he shall inform the court about it. And the court shall thereupon give notice. This is the most important. The court has to give notice to that effect. He has been expired of such deaths to other party, that is the other party. And for this purpose, the contact between the pleader and the deceased party shall be deemed to success. For the reason, since that that has been occasion, so there is a contract between them. Earlier, the deceased advocate and the this provision has been made, and these two things mandatory that the court, the concerned advocate has to submit notify to the court, and the court has to give a notice to the other party. In this impugn order, no such notice has been given. No whisper has been mentioned. Whether notice has been given to them regarding that thing, Now, may I take your honor to the applications which have been filed, which is annexer D page 40. We have specifically
Which application?
our application,
Page?
page 40, annexer D.
Hmm.
We have categorically stated, number 2, that 11/6/2014, the advocates for the respondent has filed 2 documents before the learned honorable court. One of the death certificate in Mr. Thekara Boro, that is the respondent 1, defendant number 1, and other the list of family members of Thekara Boro. Of the respondent 1, according to this court, this honorable court was pleased to pass orders and directing the appellant to take steps to substitute the names of legal heirs of Thekara Boro, that is so and so, so and so. That enter in the objection they have filed by the defendant number 1,
Hmm.
the Bhubaneswar Boro. He did not deny it, that he has not submitted a death certificate or did not give the list of documents, or
Where is the objection?
page 44. This
Hmm.
this has been submitted by Bhubaneswar Boro. Other defendant has not submitted their objection. Only Bhubaneswar Boro himself has filed this objection. Only based on this objection, this impugned order has been passed.
Okay. All right.
Your Honor.
Hmm.
Now,
So there is no notice that that person has died by the party.
party.
Hmm.
Only when we come to know that the death certificate and the application submitted by the respondent number 1's counsels, we have known that yes, the other person has been expired. On that count, the court has to give a notice to the other party. Now the number of judges here I placed.
You are arguing on the revision petition.
Yes, if you are also
This is for fixed for orders, I think, not for hearing.
orders.
Because of these applications.
Yes, yes, these
Yes,
applications.
we'll have to take up everything together, I think.
Yes, yes, yes.
Mm. Yes, we'll have to take up everything together because this case starts with the revision petition only. And thereafter they have filed the applications. Whether these are maintainable or not, it has to be decided altogether.
But
Mm.
fix the date for one date.
Fix a date.
Then we will decide, we will argue the matter.
Yes, yes, let him
Because it-
finish his
it
part,
is-
then for you I'll fix a date.
It is the year of 2015. The order is enjoying last 10 years.
Yes.
It is a partition case between the family.
No, I'll dispose it of. I'll dispose it of. If you place a submission today itself.
Yes, argue the matter that already my names are already impeded. We have the legal year in the plant.
Hmm.
Then they have lost, they are the plaintiff, they have lost their case. Then at the appeal stage, they come to this. So
Whether they have a case or not, I'll decide it.
Madam.
Yes.
No, the issue is that regarding this petition, dismissal of the petition, nothing else. The merit we will look after in the trial. We have decided whether this petition, rejection of petition.
All right, all right.
the rejection of petition only on the ground of limitation, madam.
Yes, yes.
Suppose I have not.
Limitation of a few months, 10 months.
10 months.
Hmm.
Because I have furnished, I have not furnished the names, other name, because already my name is there, all the legal year. It does not mean that I have not furnished the name of the legal year, you will not file the limitation, but application for limitation. Is it the procedure of law? Madam, fix the date.
I'll fix a date.
I-
Let him finish his argument, I'll fix a
Madam,
date.
Now, if you look at Gangadhar's case, Your Honor, it is one of the Supreme Court has categorically held me to detail. One to report case. I will case Gangadhar's case. Regarding the no. Sir. Section para 6 of the Gangadhar's case, you know.
Yes.
Why 10 is necessary, Your Honor.
Hmm.
Sole
Huh? I'll just come after 5 minutes.
okay.
you have a
Yes.
So dispose of the case.
On hearing day.
18 on 18.
18th, my letter.
No, not on 18th. On 20. On hearing day.
20 maybe.
All right then. I have kept the judgment.
Yes.
You'll need it.
No, Lordship, I have, yeah, I can. If I will submit
Any other
another,
judgment?
any other time, I will also place on that day, I will place on it.
Yes, yes.
Not all right.
It will revision patient to law thaba, huh?
Another 20th. 20th of March
20. Hard learned council
for hearing.
or hard learned ally. Parties are represented.
Part
List
had,
the-
my lord, part had were for hearing.
Okay.
Not all.
Part had argument. List the matter for. This is hearing or orders?
Actually, orders for there, but we want to finish it because maintainability of the chair.
Hard learned council for the petty. List the matter. No, cannot keep it as part hard. It is not hearing. It is in the orders column.
Yes,
order.
yes.
Okay. Parties are represented. List the
Fix
matter on
it, fix it.
20
Fix it.
2003 2025.
40 seconds.
I am very much here.
Well,
Item number 10.
Yeah, please, Your Lordship.
Hmm.
Actually, my senior, like, future Chakrabarti, she would have conducted this matter, Your Lordship, but
Hmm.
she is there in the hearing for in court number 16.
Hmm.
So if Your Lordship may permit, then I may argue the matter here in this case.
You want to argue?
I can start, Your Lordship, because it may also be kept part hard, because on the last occasion, the respondent said they did not appear on last two occasions. So, Your Lordship, so it has been picked that it may be disposed of on merit.
Hmm.
So, Lordship, if may permit, then I can also argue the matter of it.
Actually, appeal is not required to be argued on merits, but if the other side is absent, we can take it up. Today, you want an adjournment.
Your Lordship, because my senior, she would have conducted the matter, but large number of hearing cases are there in court number 16. So it
Hmm.
may, it will further get delayed. So if Your Lordship may permit, I can start with stating the fact and
Hmm.
praise the court a little bit later.
But you will
on the
not
matter.
conclude it today.
Your Lordship, her judgment is also there of this
Hmm.
honorable court.
If
which is
you
also
if you
covering
are
the-
to conclude it, then I'll take up the matter, but not that's part hard
Your
because
Lordship, I'll try to conclude it, Your Lordship.
yeah.
With some judgments are also there in the final court.
So you want to conclude it? All right.
Your Lordship, this MSCT case, this FMAC appeal, it has been filed against the judgment and order dated 23/2/2015, passed in MSCT case number 57/2010, passed by the learned member of the Honorable Motor Vehicle Claim Tribunal, Goalpara. The appellant opposite, we are appellant, the opposite side 456. We have preferred this appeal and this under section 173 of the Motor Vehicle Act 1988. So, Your Lordship, here in the learned court below, we actually were not representing this matter, Your Lordship,
Hmm.
and this judgment it went ex parte, Your Lordship. Then, so the Oriental Insurance Company, which was being made a party to this
Hmm.
case, they had appeared and they had submitted the written statement also. So, but as the railway did not appear and did not make the submission, it went ex parte. But Your Lordship, here we have placed and we have been awarded. Lordship, I'd like to draw your attention to the judgment at page number of the appeal. Page number 24, Annexure 3 to page number 31, Your Lordship. Your Lordship, I would like to read the judgment that has been passed by the Honorable Learned Court. So, Your Lordship, here the respondent, who was the claimant there in the court below, has it has been mentioned that they specifically has not been mentioned whether he's the father of the claimant or of the deceased, or but has been written as a representative here. So this proceeding, I'd like to read the judgment, paragraph number 1, Your Lordship, here.
Page number?
Page number 25. Lordship, paragraph number 1, this proceeding under section 163 A MV Act is initiated by claimant number 1 Kasim Ali, son of Sabaruddin Molla and his wife, claimant number 2, Muhammad Surbhan Khatun, both village, Khashiasin, part 2, PS Morioni, Mornoi, district Gwalpara, who have applied for grant of compensation of 5.5 lakh as legal representatives on account of the death of their son, Rezuddin Ahmed and Aziuddin alias Rayazuddin, who died in motor vehicle accident occurred on 29/4/2006 at about 7:30 a.m. at railway level crossing unmanned number 176 at Moijonga in between Krishnai and Gwalpara town station, caused by train number 5642 down Jhaja Express and truck number WB25/0487. The victim died on the following day at the hospital. He was the driver of the said vehicle, which met with an accident. The claimant had made the deceased, the victim, as opposite party number 3, and it has been inadvertently done. The offending vehicle, that is the truck, under registration number WB25 WB25/0487 was insured with opposite party number 1, Oriental Insurance Company Limited, Bongaigaon Division, Bongaigaon, under policy number 313306, valid up to 4/12/2006. Opposite party number 2, Tapesh Aich and son of Ashok Aich of 83 AKNG Road, Barasat 24. PJS North Bengal was owner of the said vehicle. The claimant had made General Manager claims, NF Railway Maligaon, Guwahati, District Kamrup, Additional Chief Engineer, NF Railway, and Bhalu Dubi, PS and District Gwalpara, and Executive Engineer, NF Railway, Bhaluk Dubi, PS and District Gwalpara, opposite party number 4, 5 and 6. It may be noted at this stage that all these opposite parties did not contest this proceeding. They were set as ex parte. At the time when the victim met with the motor vehicular accident, he was aged 23 years. He was a regular employee of the opposite party number 2, and he used to earn a sum of rupees 3,300 per month from his avocations. Postmortem was done at Guwahati Medical College, and the conducting doctor opined that the death was caused as a result of the injuries sustained on head. Paragraph number 2, opposite party. Here, Your Lordship, here few issues have been framed, Your Lordship. Paragraph number 3, here I would like to read. The consequent upon the pleadings, the following issues were settled for determination. Number 1.
So you did not appear before the tribunal?
No, Your Lordship, it did not appear, but it went ex parte there in this matter. FIR was being filed by the police then when the accident had taken place. And here, Your Lordship, I'd like to draw your attention to paragraph number 9, which has been specifically mentioned.
See, you did not appear.
Yes,
So did you file any application for vacation of any ex parte judgment or order earlier? No.
No.
You directly
Your Lordship,
approached for
directly
appeal.
approached to the Honorable. Here here a similar matter case is also there, Your Lordship, which has been recently decided by this honorable court. So I'd like to place the judgment. It has a similar fact of this matter, and it has been said that the railway need not pay the liability or whatever compensation has been given.
That railway crossing was unguarded railway
Unmanned crossing, Your Lordship. So here, whether the witness, there was only one witness, the father of the deceased had only been the witness. No witnesses from the even from the
Does
insurance.
proceedings have been stayed?
No, yes, Your Lordship. Yes, interim order.
Have you deposited 50% of the claim
No.
compensation? No.
No, yeah. Your Lordship, we have there in this particular judgment, there has no mention has been made whether the railway, the jurisdiction of this honorable the MSCC court is there is a jurisdiction, or whether it should be referred back to the Railway Claims Tribunal, because under the RCT Act, the Railway Claims Tribunal, they have the jurisdiction to enter
Yes.
regarding the accident, and also under section 124 of the Railway Act, It also specifically speaks that if there is any untoward incident or unmeant, so railway has no liability in regard to that. So here in that particular judgment, Your Lordship, it has been specifically mentioned all the points and all the grounds that we have mentioned here in this appeal, Your Lordship. It has also been taken care of there, and we have been discharged of the liability, Your Lordship.
Where? In which paragraph?
Your Lordship, in the judgment. So, Your Lordship, paragraph number 24, page 6. Here, now it is clear on the face of the record that the driver, Lok Bahadur Chhetri, had violated the provision of law as laid down in Section 161 of the Railway Act 1989. It is proved that the accident took place because of the negligence of Lok Bahadur Chhetri, who was driving the vehicle bearing registration number such and such. In that case, the appellant and actor are not liable to pay any compensation to the claimant. So
Because the driver was made liable.
the driver
Yes,
here
you can
also-
continue. Yes, you can
Please,
continue.
please.
My lord, in this case, rail was made party, my lord.
Yes.
So we are not telling that these accidents occur in unmanned level crossing.
Yes.
With the motor vehicles. So railway should not be made party in the MSCT tribunal, MEC tribunal. So if it is against the railway, it will be in the railway claim tribunal. So it is not filed in the railway claim tribunal. It is in the motor claim tribunal file. Railway is unnecessarily made party. This is our question, my lord. We have taken a ground, so many grounds, my lord. My lord, already in similar matter case, my lord, this honorable court passes judgment. The driver or the insurance company is liable for that. So rail is not liable. So my lord, I have related judgments of this honorable court, my lord.
Already given.
Given. I'm in court number 16.
Yes, I know. If you want some time, then I can give you some time.
No, my lord, this is the simple case, my lord. In the Bombay, Punjab and Haryana High Court also, claim against the railway judicial tribunal is barred. This judgment of the,
Yes.
I think we got.
Punjab and Haryana. No, I have got our High Court's judgment.
Yes. Then, my lord, if bus locked by railway engine at level crossing, railway admission need not to be added as a party. This is the of the Guwahati High Court, my lord. Then, my lord, the Supreme Court decision was there. Then, my lord, the Central Motor Vehicle Rules 1989, Rule 100F, negligence, unmanned level crossing, common law duties of driver or motor vehicle while crossing such crossing, while writing on signboard requiring vehicle to stop and also requiring conductor to the vehicle to get down for checking and contemplated by the rule, not visible. There is no duty in absence of signboard on the driver or a conductor. However, common law duty to stop, see and hear was the nevertheless. Driver stopping vehicle at the level crossing. His driver was guilty of negligence even though there was no curb or obstruction at this point. This is the decision of the Supreme Court.
Which paragraph?
Paragraph is 7, para 7. Then, my lord, then another decision of the Supreme Court, my lord, 1997 8 SCC, para 7 and 8, my lord. In absence of signboard, there is only common law duty to stop, see, hear, and find out if any train was coming. But there where the driver even did not stop and the vehicle at unmanned level crossing, which resulted in an accident when a spending train dashed with the bus, held the driver was guilty of negligence. This is the 1997 Supreme Court decision. I think then year 1986, Punjab and Haryana High Court, the meaning of claim against railway, judicial of claim tribunal is barred. Para 31. Claim table is set up for adjudicating upon a claim for compensation in respect to accident involving the body injury to a person arising out of the use of motor vehicle or damage to any person or third party so using, so or both. The tribunal has not been conferred with the jurisdiction to deal with the claim of the compensation in respect of all kinds of accidents. Instead of this, jurisdiction is conferred to claim compensation in respect of those accidents which arises out of the use of motor vehicle. In other words, the use of motor vehicle must be cause of the accident, however slight it may be, and unless the accident is affected caused by the use of the motor vehicle, it would not be possible to say that it has arisen out of the use of the motor vehicle. Para 33, it is not illegal, and when a claim is filed against railway authorities alone, alleging that accident took place entirely because of their carelessness and negligence and the driver of the train and gateman, and there he has no allegation that motor vehicle in any way contributed to the cause of accident. It cannot be said that the same arisen out of the use of the motor vehicle. As such, this claim would not be entertained by the tribunal, and instead would be competent only in the civil court, AR 1982, AR 3110. Explain my letter. Para 31 and 33. So this is in our favor, my lord. We should not responsible for that. If it is caused by the railway
So
accident,
railway was directed to pay the compensation,
yes, my lord.
not the insurer.
Not insurance. No.
I think the vehicle was
50,
insured
50.
also.
Insurance to 50%.
This is para 31 and 30.
Yes, my lord.
Para?
Para 31 and 33.
Okay.
My lord, insurance 50, they are directed to railway to give the 50%. 4 lakhs something.
Okay.
The opposite party 4, 5, 6 are directed to pay an amount of 1,18,100 all as a compensation to the claimant within 2 months. This is only for 4, 5, 6 the railway, no? Only they directed the railway, not the insurance company, nothing, nobody, no, not the owner of the vehicle. So only the railway. The railway is not entitled to make payment of the compensation, madam. Railway, the motor accident claim tribunal has no jurisdiction to pass any order against the railway.
Yes.
This is my submission, madam.
We have a different railways tribunal.
Yes, madam. Claim tribunal is there. They could have approached to the claim tribunal. There are more 3 cases in there. More 3 cases I have to argue there.
Today.
Today.
Heard learned counsel, both their names I'll.
Yes.
Heard learned counsel Miss M. Chatterjee, and learned counsel Miss U. Chakraborty, learned special railway senior counsel Miss U. Chakraborty for the
for the appellant.
Full stop. The nine. নালাগে নেকি থৰ পাৰিলে আজি দি দিম মই টাইম হ'ব না There's an IA also.
Yes, I may be close, my lord. After judgment in this case, my lord, I may be close to my lord.
Heard learned counsel Miss M. Chatterjee and learned special rail senior learned railway senior counsel Miss U. Chakraborty for the appellant. The names of the respondents, the name of the learned counsel for the respondents is reflected in the cause list. but the respondents are not represented today. Stop. The respondents were not represented on the earlier dates as well. List this matter for list for judgment and order. Reserve for judgment and order. List not. Reserve for judgment and order.
I may be closed for now.
Oh yes, sir. Yes.
On the basis of
I
that,
too closely. As this case is fixed for as this case is reserved for judgment order, I interim order. Oh.
after the passing
Close.
judgment in the interim order, this is interim
Let
order.
it remain open. Yeah.
Okay. Lordship may pass the judgment of this.
This I is relating only to interim order that of stay.
Okay.
Then it's left open.
Item 11.
No. Other side is not present.
Long pending case, okay, there entering the stay order.
Stay. One more, we can dismiss it late on the next date if they are not present.
Next week, okay.
But questions of law have been framed.
Yes, okay. It is admitted, it's for hearing.
Oh, admitted, and it is for hearing. Yes, yes.
16 matter. 16 matter.
2016 matter. You are the respondent representing the
Plaintiff.
plaintiffs. What this case is relating to what?
Suit relating to specific purpose of contract. And this suit was originally dismissed by the trial court. Thereafter, the appellate court decreed the suit. Against that order, they have preferred it. Admittedly, they have agreed that money has been paid. Only one question was there, that as per section 16C of the Specific Claim Act, there should be a statement that I'm ready and willing to perform my part of the trial court dismissed the suit on the ground. There is no adherence in the claim that plaintiff is ready and willing to perform his part of the. On this count alone, this suit has been dismissed by the trial. But the appellate court has came to a finding that there is averment in the claim that directly or indirectly there is the averment that plaintiff is ready and willing to perform the part of his part of the contract, and so plaintiff is entitled for decree for specific purpose of. So against that order, they have preferred appeal, and the substantial question of law was framed regarding 16C only, whether the 16C requirement of that I'm ready and willing to perform my part of the contract in toto is necessary in a pleading by a person claiming for specific contract. And Supreme Court has already decided this point that only averments that I am ready and willing to, this specific statement is not required. From the reading of the plain and from the statements made in the plain, if it is disclosed that plaintiff has ready and is willing to perform his part of the contract, there is an. That is a full bench judgment of Supreme Court. It's a simple matter, not a complex matter.
So we'll allow one date.
Okay.
If they don't turn up, then we will decide on the substantial question of law.
Next week, because it will not come. Next week, any date.
Yes. Learned Counsel, Mr.
S.K. Goswami.
S.A. Goswami is present for the appellant, for the respondents. The appellant is not represented today. List this matter for hearing positively on the next date fixed, failing which necessary order will be passed.
On 18th. 18th.
Not on 18. Not possible.
20. Or less.
Item 12. Item 12.
Respondent, the appellant and the respondent are not, and the respondent number 3 are not represented today. List this matter after 1 week.
Item 13.
Lordship, this is a death due to electrification matter, Lordship. The respondent therein was very plaintiff's Lordship. They had preferred a suit for compensation to the tune of rupees 27 lakhs 96,000. The learned trial court has granted a compensation of rupees 10 lakh. Aggrieved by that order, I have come before the honorable court. Lordship, if your Lordship takes up the judgment of the learned trial court, page 74, Lordship. The last para, issue number after issue number 3. Issue number 4. This issue is whether the plaintiffs are entitled to the compensation as paid for. The plaintiffs in the plaint prayed for compensation of rupees 27 lakh 96,000 from the defendant. The plaintiff and PW1 also stated and deposed that the deceased was serving as assistant teacher at Roypara LP School and used to draw a monthly salary of rupees 8,000 per month as an honorarium from the school committee, as the school was not provincial. Monthly salary of rupees 20,000 per month. PW1 exhibited an attested copy of an order of appointment as assistant teacher of the deceased Vinay Chanda at Roypara LP School with effect from 6/1/2002. In the said letter, there is no mention about any salary to be paid to the deceased. It is simply mentioned that payment will be made when the grant is sanctioned. Also, there is no document to show that the school got provincialized after the death of the deceased Vinay Chanda. In view of the same, it cannot be said that the calculation made by the plaintiff claiming compensation is proper. However, in the event of the defendants being held liable under strict liability as decided in issue number 3, the defendants are liable to pay compensation to the plaintiff. Considering the same, the defendants pay us lump sum compensation of rupees 10 lakhs to the plaintiff. It's a case where there is contributory negligence also, Lordship, because the husband of the plaintiff, while going to the field, he have touched the live wire himself with his hand in order to free the passage for the bullocks and everything. That has been admitted, Lordship, in the cross-examination of the plaintiff witness number 1. PW1, Lordship, if your Lordship takes up the cross-examination, Lordship, page 48.
Yes, page 48.
Page 48, Lordship. This is the type copy of the cross-examination.
Cross, yes.
PW1, that is the wife of the deceased. Lordship will see that I am the only witness in this case. My mother-in-law is old aged and my children are minor. There is no other witnesses. The occurrence took place on 21/7/2013 at around 6:30 a.m. I have not seen the occurrence personally. The occurrence took place near a tila at a distance of 1 furlong. It is not a path occurrence took place on field. My husband was going for cultivation. Earlier to that, I had never seen snapping of live wire. It was in the month of Shravan. Previous night, there was a heavy storm and wind also. My husband tried to remove the wire for passage of human and bullock, and as a result, he was electrocuted. The electric wire was in his hand. Defendants were not informed about the snapping of the wire. If defendants were informed early, they could disconnect the line. It is a fact that the concerned electric line was never loosened or snapped only on that night due to storm and snap. Workers of defendants came after 2-3 hours and cut the lines in 2-3 houses. My husband was a teacher of one venture school. It is not a fact that my husband was not a teacher, he is only cultivation. I have filed a certificate signed by headmaster of the school. So, my lord, he has admitted that the husband, while going to the paddy field, had removed the live wire without even informing the other officials, and the live wire was snapped at around 2:30 a.m. at night, which was humanly impossible for any electrical officers to come and look for the after a thunderstorm. And that has been also there in the post-mortem report, my lord. The post-mortem report at page 67, it has been clear, my lord. Your Lordship takes up page 67 of the post of the appeal memo.
Page 67?
67 of the appeal memo. I have annexed the post-mortem report.
Yes.
Here, if my lord sees more detailed description of injury and disease, all the findings described above are anti-mortem in nature. Presence of characteristic Joule burn indicate that these burns was caused by passage of high voltage electric current over the body through the palm. Passage of high voltage current over the body, ventriculation, filtration in irrelevant cardiologic shock equals to death. It's clear that after the deceased had himself touched the live wire in order to remove. I am the exceptions to this strict liability were complete given go by the learned trial court. And regarding the compensation of rupees 10 lakhs, there is no any document supporting his either his in this school for how many years he has been working, and no age proof have been provided in this entire trial. Even they haven't exhibited any documents to show as though he was working in that particular school, and as to how much salary he has been earning. Because in the plain, if your honor sees, plain they have admitted that he was receiving a salary of rupees 8,000 as honorary. And even though in page 34 of the plain, the plaintiffs have themselves admitted that the page 34 of the plain method.
All right.
Para 7, my lord, they have admitted that the deceased was a teacher and serving as assistant teacher under Roypara LP School with effects from 16/1/2002 till death, and he has drawn salary of rupees 8,000 as honorary from the school committee, as the school was not provincialized, but after the death of the deceased, now the school is provincialized, and the deceased alive, he will get a salary of rupees 20,000. So in this entire calculation of the plain lordship, there nowhere there is mention about the age or the how many serving age he was yet to serve before this school, or the salary slip or nothing has been given. Without going through any of the documents, this learned trial court passed an order giving a compensation of rupees 10 lakh. And one more thing, lordship, there was a mandate as per section 161 of the Electricity Act that has been violated, lord. That was not followed itself. We have taken that stand in the written statement also. If your lordship takes up 161 of the Electricity Act.
This is the Electricity Act.
Yeah.
Yes, you can.
Electricity Act, lordship, section 161. It is a mandate given in the out here. Notice of accidents and inquiries. If any accident occurs in connection with the generation, transmission, distribution, supply or use of electricity in or in connection with any part of the electric lines or electrical plant of any person, and the accident results or is likely to have resulted in loss of human or animal life, or in any injury or to a human being or an animal, such person shall give notice of the occurrence and of any such loss or injury actually caused by the accident in such form and within such time as may be prescribed to the electrical inspector or such other person as aforesaid, and to such other authorities as the appropriate government may by general or special order direct. The appropriate government may, if it thinks fit, require any electrical inspector or any other person appointed by it in this behalf to inquire and report as to the cause of any accident affecting the safety of the public, which may have been occasioned for by or in connection with the generation, transmission, distribution, supply, or use of electricity. As to the manner in and extent to which the provision of this Act or rules and regulations made thereunder, or any of the license so far as those provisions affect the safety of any person have been complied with. Every electrical inspector or other person holding an inquiry under subsection 2 shall have all the powers of a civil court under the Code of Civil Procedure 1908 for the purpose of enforcing the attendance of witnesses and compelling the production of documents and material objects, and every person required by an electrical inspector be legally bound to do so within the meaning of section 176 of the IPC. Lordship, this is a mandate that has to be followed. Even though we have taken that plea in our written statement that a report from the electrical inspector is necessary in order to what to say, in order to go through all these a report that is the mandate and it has been followed. But in this case, no such report was there. Neither was even called for even after taking that plea in the written statement. Lordship. So these and one more thing, Lordship, the limitation as prescribed under Article 81 of the Limitation Act, they had to file the suit within 2 years from the death of the deceased. That was also not filed within 2 years. But my main concern is that, Lordship, the compensation amount of rupees 10 lakh. Without any supporting document, the learned trial court awarded amount of rupees 10 lakh, my lord. My lord, I will very well interfere with that. That too, when there are evidences to show, the PW1 has herself admitted that he had touched the wire himself, and the post-mortem report also suggests that same thing. By not going into all those aspects, the learned trial court simply came to an erroneous conclusion that rupees 10 lakh shall be given as a compensation amount to the deceased. I am only on that limited ground of challenging that the compensation amount may be reduced or as your lordship interferes. My humble prayer is that.
All right.
So he has already limited his prayer. So I'm not going here and there. So regarding compensation, Lordship, 10 lakh only has been awarded. 8,000 per month
Was his honorarium.
honorarium that has been left by the complainant. It's clear. Other proof is not there. It is sufficient proof honorary that in that part evidence has been adduced.
Yes.
By calculating all this 8,000, the minimum which has been awarded. Rest is up to your lordship. Other salaries, all the things have not been there since it is it has not been provincialized. School has been provincialized.
He will receive area if school has been provincialized, and that she will, I think, I don't know, now they are receiving 100% of the salary after one notification, but maybe she will get the pensionary benefits maybe.
Before provincialization, he occurred.
So maybe he'll get the pensionary benefits.
He will not get any benefit.
Pensionary benefits
No,
he'll get, I think,
nothing.
no,
So
because he has passed away.
he passed away.
He was not appointed as a
Since
teacher of
provincialization was not there yet. Small children.
So that future prospects are there. Okay.
No other any.
You are on, so if you agree, then I can bring down then and on agreeing, you can settle the dispute if you are agreeing
My lord,
to bring down the compensation. Otherwise, I can pass a order on merits. What do you say? It's up to you.
My lord, my only grievance is that without any supporting documents, their compensation was allowed. My only that
Actually, through register, they pay the salary. The salary is entered in a register, and then in government school,
yeah, but that in fact that register was also not produced in evidence.
provincialized school, not involuntary, what this is called? What type of school?
Venture
Venture schools. So in venture schools, this is the method of payment. They do not have a pay slip.
Yes.
That could be called for, my lord, in the stage of evidence.
My evidence, which is 8,000 per month, has not been perfected during trial. This has been.
If you agree, then I can bring it down. He is saying that that the compensation may be lowered, but if the compensation is lowered, also she will not get sufficient benefits, or else I can pass an order on merits.
If it is 1 and 2 lakhs, then otherwise,
Otherwise, I'll pass an order on merits. 8 lakhs. If 8 lakhs, then he is agreeing.
My lord, there is an compensation to victims. That is a notification that by the Assam Electricity Regulatory Commission. There we have a guideline whereby we are saying that because
Where is the notification?
This one I have the.
According to the guidelines, how much
According
has
to
to
the
be
guidelines,
paid?
my lord, at the amount payable for loss of human life is rupees 4 lakhs.
4 lakhs.
4 lakhs. But otherwise, I have no documents have been supported. So, my lord, I think it is a justified amount.
Notification of 2013,
Yes. 2013, there
2019,
19.
not 13, 2019.
13 there was another office memorandum, but there it was 1,60,000. But the age certificate, nothing was there. At least how many years was his office tenure was left. That also nothing has been given. So based on that itself, the office memorandum was
Quantum of compensation schedule B,
still with that it's 4 lakh lordship.
the compensation payable for loss of human right as a result of electrical accident. So this can be paid legally.
Yes, that is in the year 2000. Otherwise, if any documents were provided by them, then I have no objection. But no documents are there. The salary slip, neither the age of the deceased was also there. Not there. And regarding the aspect of contributory negligence, that was not dealt with by the civil court.
Okay, let us proceed. I'll start dictating the judgment. Others can leave. It will take me at least 1 hour, I think. They are not coming to a settlement, so it will take me at least 1 hour. I will take up after at 2, 2:30 maybe. 2 at 2. I won't be able to complete by now. I think dictation I'll just start. If you settle the matter, then you settle, then it will end in 1 page.
Now, what I am sharing, my friend, if it is settled, he can take a date for date 2 to 3 days, he can take instruction.
My instruction is there, Lordship, that we are in fact ready to pay this for 4 lakhs. That as per the-
Definitely, he is ready to pay the 4 lakhs. He will pay because
that is
it
the
is
guide-
allowed.
That is my instruction that I have received.
You want a date? Or you want a date, or should I start
By 2, Lordship.
by 2? Oh, yes. Okay. All right, by 2. You obtain instructions, and then you also take instructions, and then at 2 we'll decide this case. So who? Everybody has left, I think, by now.
Next time here. I have 49 years, my lord.
এইটো 2টা বজাত দি দিবা।
My lord. My pleasure, lordship.
Yes.
This is a matrimonial appeal, my lord, against the passed by additional district judge, that is the for your lordship. Basic challenge is made, my lord, here, but otherwise, I'm not going on in detail, my lord. We are challenging only basics on one judgment which was placed before the learned trial court.
So I'll pass an order.
They are ready to pay the 4 lakhs. The 4 lakhs, that the amount they are ready to pay.
You are not agreeing with 4 lakhs. Okay.
Because this act will not apply. Illicitly act. So the federal act is there under this calculation. So if we calculate in that way, Lord, it will be on 10. Lord.
Judgment টা ডিক্টেশন দিব লাগিব বেলেগ মাতি মিনুক মাতি দিওঁ নেকি হা লৈ ল'বা ঠিক আছে দিয়া Heard learned counsel, Mr.
A Deca, Lord.
A. Deca for the appellant or petitioner appellant. Title appeal, it was a title suit, no?
First, it was a title suit.
uh, comma, comma, right, and learned counsel, Mr.
I for yeah.
You are for the, no, you are not, you are for the government advocate, no?
No.
Standing counsel for
I'm appearing on behalf of BD Rekha.
State
Yes, sir.
Electricity Board? You are for the State Electricity Board?
No.
APTCL.
APDCL.
Assam Public Distribution.
Yes, APDCL,
Yes.
not Electricity Board, APDCL.
APDCL.
Standing counsel or learned counsel
Learned counsel.
for the appellant and learned counsel, Mr.
I for yeah.
I.S. Borvia for the respondents. The appellant in this case, appellants in this case are the Assam Power Distribution Company Limited, comma, the Chief General Manager, comma, the Senior Manager, comma, the Deputy Manager, the Chief General Manager, এনেকে লিখি দিবা গুৱাহাটী লিখি দিবা হা গুৱাহাটী Chief General Manager hyphen Guwahati, the Senior Manager, the Deputy Manager, comma, the Assistant General Manager, comma, Hailakandi, and the Assistant General Manager Law, comma, Bijuli Bhavan, Polton Bazar, Guwahati. The respondent is Srimati Archana Rani Chondo, and the respondents are the respondents are to Katidia. Srimati Archana Rani Chondo, comma, Sri Biswajit Chondo, Sri Bishal Chondo, Bikramjit Chondo, and Srimati Sayarani Chondo, alias Chaya Chondo, are arrayed, ARRAYED, as respondents number 1 to 5 respectively. The appellants are agreed by the judgment and order passed by the learned civil judge Hailakandi in connection with money suit number 8 of 2016, whereby the appellants were directed to pay a compensation of rupees 10 lakhs to the respondents. Now, Pawan, it was oh, just a moment. You are waiting for the so we'll defer it for another date or for mediation. What about the other side? Okay, then if he's agreeing to mediation, then we'll pass an order for mediation. I'll need at least 30 minutes time to complete this dictation. If you have some other work, you can go and complete your work and come back. No, I'm addressing to the hall. If you have some other work, everybody in the house, if you have some other work, you can come back. Oh, at least 30 minutes, at least. compensation দিয়াটো। The learned counsel for the appellant has submitted that the learned court has ignored the fact that there was contributory negligence on the part of the deceased, which led to the unfortunate incident. There is evidence that the cross-examination, the cross-examination of PW1 clearly reflects that the deceased touched a live wire which snapped, no? Which snapped. So it was in the wee hours of the morning at 2:30 a.m. when the incident had occurred, and it was not possible for the officials to come to the rescue of the deceased at that point of time. The PM report problem PM report is Annexure 6.
Page 65 onward. Annexure 6.
Annexure 6, no?
Yes.
The PM report. This is your, you have marked as Annexure 6, or it is in the.
No, I have in the appeal memo I have marked.
You have marked.
Yes.
The PM report, marked as Annexure 6 of the appeal memo clearly reveals that that was the result of burns. That was the result of colon diple, burns caused by passage of high voltage electric current over the body through the pumps, PALMS pumps. The compensation was assessed on conjectures, CONJECTURES, conjectures and surmises, as the respondents stroke plaintiffs have not submitted any age proof or salary statement of the deceased. Full stop. It has been vaguely mentioned in the plaint that the deceased during his lifetime was receiving a remuneration, an honorarium of rupees 8,000 per month. একদম বিগনিঙত লিখি দিবাচোন। The title suit was brought up against the appellants by the family of by the plaintiff within bracket, also referred to as the respondent bracket close, as the appellant number one's husband, respondent number one's husband.
No. Yes. Respondent number one.
Respondent number one's husband died as a result of electrocution alleging negligence, electoral location, full stop, negligence has been alleged against the, first stop beginning of by the APDCL, APDCL maybe, by the Assam Power Distribution Company Limited within bracket APDCL for short bracket close. The appellants are aggrieved by the judgment and order passed by the learned. এইটো এবাৰ লিখা হৈছে ন, কালি এতিয়া লাষ্টলৈ আহাচোন. It is further submitted that this appeal or the title suit was also brought up against the appellants after the expiry of the period of limitation as per Article 81 of the Indian, as per Article 81 of the Limitation Act of 1963, within bracket the Act of 1963 for top Article 81, Article 81, full stop. The title suit was not filed within 2 years or within the period of limitation. Title suit number 2. You have filed any objection? Oh. Have you filed any objection?
Okay.
In this written, no written objection.
No written.
That
It is an
has been
appeal.
done.
As per Article 82, sorry, as per Article 82 of the
82,
limitation, right?
Article 82.
Article 82.
If it is regular appeal,
No, somebody submits the written statements.
No.
Some, not written statements, arguments.
argument.
Prior to their submission in the court, some parties they submit written arguments. That's why I'm asking. They have submitted. The learned counsel for the respondent has submitted that a judicious order has been passed by the learned civil judge. Full stop. This appeal is bereft of merits. Full stop. The deceased was a teacher in a venture school which was provincialized in the year, which year? Which was subsequently provincialized. Full stop. The deceased had great future prospects and he would have earned a regular salary had this unfortunate incident not occurred. Anything else?
8,000 which has been in our state also and in our evidence also read by the witness. 8,000 which has not been disputed by the
it is not disputed that the deceased was during his lifetime was earning rupees 8,000 per month as salary, and salary. Electrolocated during a cyclonic storm will লিখি দিবা হা electrolocated লিখিছিলা যে it is a result of in a during a cyclonic storm. It was a cyclonic storm.
Yes, from the day before the incident.
But around 2:30 a.m. the fire was snapped. And
That I have noted down. Only I have not mentioned this 161 of the Electricity Act That I will mention while discussing.
One line may I add here.
Yes. Yes.
Regarding contributory negligence to be based by what contributory negligence one has to know, has the knowledge of this living where is there. Unknowingly I have touched. This touch is obviously there why the electrification is come. So unknowingly I have touched. Regarding foreign wire.
It is further submitted on behalf of by the learned counsel for the respondent that uh, this case cannot be said to, this case is not a case of contributory negligence, as the deceased touched the live wire unknowingly, which is also evident in the, which is which is also evident unknowingly. Full stop. The negligence was
Because he happens to be a teacher at college of live wire calling.
So whether wire is alive or not, that may not be determined.
As per the
because wire is lying in the field.
this happens very much in this area because due to storm,
Yes, madam.
there's there are so many incidents of electrocution in that area and negligence also. Usually in the village areas in this area in Assam, throughout the state of Assam.
With PW1, he has admitted that that was not a loosened wire. Wire was otherwise okay. She has admitted in the cross examination.
The place of PW1 is in the household.
Sometimes it so happens, you know, one person died when he put his feet in the puddle, and there was he was electrocuted. It happened in Guwahati during the monsoon season. This happens.
That's why
Very unfortunate.
That's why your fixed liability has come, and one judgment also referred by the lower court below of our high court regarding fixed liability.
Regarding what?
Fixed
Liability.
Where?
The exceptions of this liability.
In which page?
GLP, GLR.
The judgment itself.
73, page 73. Paragraph 14.
Page 76.
73. Paragraph 14.
Yes.
Here, lordship, interest also not been counted. Lump sum amount has been. Otherwise, if you go by the chart, it's come around 12 lakh 15,000 plus 9%.
This further submitted that the deceased Bina Chanda was the sole breadwinner of his family, and the compensation is sufficient and sufficient not. And the compensation cannot be considered to be a windfall. And had the compensation been calculated with interest accrued, the compensation ought to have been ought to have summed up to rupees 12 lakhs. 12 lakhs 15,000. Full stop.
His salary is 8,000.
It cannot be considered that this is a generous compensation paid to the awarded to the plaintiff stroke defendants. So that loose or that are relating to 161 of the Electricity Act and the loose wire in the evidence, not a loose wire in the evidence, I'll discuss in the later stage. The main issue in this case can be narrowed down to, so this cause of action will not take up. Then issue number 2 also will not take up. Number can be narrowed down to number 1, whether uh, whether the appellants were negligent in maintaining LT line uh, which resulted in the death of Binoy Chanda. Number 2, whether the respondents are entitled to the compensation as a result of the death of Binoy Chanda. To substantiate their stand, the respondents adduce the evidence of এইটো কি হ'ল আহিছিলে নেকি এতিয়া এই আহিছিলে কি কৰিব নেকি ডেট এটা দি দিবা অৰ্ডাৰত আছিলে নে হিয়াৰিঙত আছে এইটোতো আৰু শুনিব নোৱাৰি date এটা দি The pleadings and the evidence clearly prove that Binoy Chandra died on 21/7/2013. Gustav, he came in contact with live electric wire and was electrocutated and was thus electrocutated. To their evidence, you have not adduced evidence, no?
No, madam.
Through the written statement, the appellants have vehemently denied that there was negligence on their part to stop. It has been submitted that the appellants the appellants who have been made jointly and severally liable were the workers under the appellants regularly visit the spot and check the electric lines, and there were no loose electric lines as alleged by the respondents. Thus, they were regularly maintaining the electric lines. Full stop. However, the evidence and pleadings of the uh, respondents, however, the evidence of uh, the respondent number one as PW1. Respondent number one is PW1.
Yes, PW1. Patna, Thane.
Archana Rani Chanda, no?
No.
Substantiates the, however, the evidence of the respondent number one, PW1, substantiates, SUB, SPA, DIP, substantiates her pleadings. She has stated that the LT line was naked and damaged due to lack of routine maintenance by the defendants and was detached from the pole, POLE, pole. Her husband came in contact with the live wire at about on in the middle of the night on 21/7/2013 and died on the spot. Full stop. An FI Ejahat within bracket FIR bracket close was lodged with the police at Algapur PS, which was registered as Algapur PS case UD case number 4 of 2013. She has mentioned through her evidence that her husband was earning rupees 8,000 per month. PW1 has mentioned it through her evidence and pleadings. You have mentioned a loss of dependency in the plaint also. The plaintiff, she has claimed for compensation as under the following heads. She has claimed for compensation under following head. Colon DP and page only loss of dependency number 1 line loss of dependency hyphen rupees 20,000 into 12 into 13 minus 5 into 4 is equal to 249,6 0. Next line, funeral rights expenses 50,000. Next line, number 3 Roman 3 loss of estate 50,000. Number 4 loss of consortium 50,000. Number 5 CON SORTIU. Number 5 transportation of dead body 5,000. You have all mentioned all this in the plaint also.
Plaint it is mentioned 50,000.
Huh?
50,000 it is mentioned.
Where?
Transportation of dead body.
Yeah, it's
Page 34.
Here it is 5,000. Loss of love and affection, hyphen, 1 lakh. it is true that no salary certificate has been exhibited by the plaintiff. It has also been argued by the learned counsel for the respondent appellant that the cross-examination of the uh, respondent number 1 clearly reveals that the incident occurred at about 2 a.m. Where is this?
Page 48, man. Page 48 is the type copy. Page 50 is the handwritten copy.
Two a.m. No, 6:30 a.m. 6:30 a.m. 2 a.m. because 6:30 a.m. 6:30 a.m. on 21/7/2013.
So this is the time of the death of the husband. Deceased. The incident occurred at around 2:30, snapping of the wire as per the plane.
As per the plane.
The incident occurred at around 2:30 a.m.
Into 6:30 about to 2 a.m. He has also admitted in a cross-examination about heavy storm and rain on the previous night of the incident. Her husband tried to remove the wire for passage of human and block. For passage and human of and bullock to facilitate people to pass, people and animals to pass, to facilitate passage of people and animals. This resulted in his electrolysis. It's true that he has also admitted in a cross-examination that the department was not informed about the he has admitted in an evidence that the department has not informed about the snapping of the electric line as a result of the storm on the previous night. The defendants did not substantiate the written statement. The defendants, evidence, did not substantiate the written statement to evidence. However, the learned counsel for the appellant has laid stress in his argument that it is not possible for the officials to or that as the no, it is not possible now, as the officials do not know about the damaged electric lines, comma, allegedly the electric line snapped at the wee hours of the morning. It was not possible for the officials to know about the damaged electric lines without any information.
Damage was occurred previous night. Previous night, 21 previous night.
Morning 2 a.m. No?
Not 2 a.m. Nothing to access. Yeah, I have done.
Then
Yeah,
previous
sorry.
night,
Sorry,
previous
occurrence
night,
previous night. And occurrence took place on
we are
21
the
seven?
morning was the previous night.
Yeah.
The learned civil judge relied on the decision of this court in SK Changri, SHANGRI, Langkang, and another versus State of Manipur and others reported in 2007 within step 4 GLJ 692, wherein it has been observed that to appeal memo from apna page appeal to asana gute appeal to RFA page page 73 para 14 আছে June পৰা itu dapat page 74 and 42 and page 74 it was held by the learned trial court that in the light of the decision of this court, in K. Changring, Langkang, in bracket, Supra, Supra within bracket, Supra, the plea taken by the defendant within bracket, appellant, in this case, in their written statement, in this case too, cannot be considered to be justified. Moreover, the appellants have not produced any evidence to prove that the said electric wire did not snap due to their negligence. It was also held that the defendants were negligent in the defendants so appellants were negligent in maintaining the LT line. which was responsible for the which led to the electrocution of late Binoy Chandra. This is Binoy Chandra. So I'm not interfering with the judgment.
Regarding the amount
Ma-
compensation itself, my lord, we are bothered with the compensation itself. That amount, because otherwise the amount is not backed by any document. And that too without any age proof, and the salary statement, as your lordship has mentioned, that I can see that register and all that, that can be
But
called
you
for.
see, this computation,
My lord, and the charges regarding the transportation and all, they are also not backed by any documents.
no, this has not been taken into consideration. Transportation,
Yes, that's all.
it was not calculated like an
Right.
LIC case.
But it was given as a lump sum.
Young children, aged mother.
Because otherwise the duty casted upon the plaintiff to prove their own case.
Yeah, that is true.
That is true, even though we
Plaintiff
have,
has to bring their own case.
Yeah. but thing is that they haven't reduced anything.
You have a judgment that they have to prove their own case. They have not got
That,
it.
my lord, I can provide.
No, not required. If you do not have today, then it's not required. I have such judgments with me, but do not have time to find.
Very old case of 16 method, 50 incident took place. They have also accused this for also after 2 to 3 years. So, and there is no loss of interest also not there. Only lump sum amount.
No interest has been.
Otherwise, interest also would have been at least
Some amount maybe.
No interest has been imposed. You see.
Yes, that my lord, I have.
In 13 method, 13 method, now it is 25.
And when this, I think this was stayed, isn't it?
Stayed. The execution was stayed, my lord.
When execution was
Yeah.
stayed.
Execution.
So when the execution was stayed, then have you deposited something to be withdrawn by the other side?
No.
I'm really very reluctant. It is true, they have to bring their own case. There's no interest also. I'll dismiss it. Sorry, I'll dismiss it. Your argument was good, very good argument, but I'll have to dismiss. So, you have stated that they have not preferred the title suit within period of limitation.
Yes, ma'am.
That you had to
Yeah, I had to raise
raise this issue in that court. That was not raised.
Yeah, that was not raised. Otherwise, the only issue that was
Otherwise, you had a good case, but it was not raised.
the only issue that was raised and not taken into consideration was this section 161, the report from the electrical engineer.
Let me see. 160.
That report can be taken within their record.
Hmm?
Current organization application has been reduced.
Let me see.
So,
Just a moment.
Uh, 161.
I have come across appeals where for 2 lakhs also they have filed appeals, PDCL. Death of children, they have filed appeals for 2 lakhs also.
Considering that, my lord, this is a huge amount.
Huh?
Considering that this is a huge
Yes, yes. In a routine manner, they file appeal, yes.
they have
It's
some
their
penalty.
official duty and they file appeal. That is what I believe. Because otherwise they will not go and file appeal for children, death of children, negligent children. He is a teacher, it's okay, but children.
Generally, normally may not
Mm.
go for it.
That to 2 lakhs. The long time back, that debt compensation was 2 lakhs or something.
Yeah, 1,60,000.
So
around.
then they award 2 lakhs, and then they come and file appeal. The learned trial court has spelled out sound reasons while deciding this case. Full stop. A minimum amount was allowed to be paid as compensation. The loss of dependency was also not calculated in its strict sense. Was not calculated strictly. Strictly. In its strict sensibility. In its strict sense. I've also taken into consideration the submission of the learned counsel for the respondents that interest have also not been added along with the compensation. The learned counsel for the appellant has emphasized to his argument that the provision of Section 161 of the Electricity Act 2003
Yes.
has not been complied with. However, at this stage of appeal, this issue is not taken into consideration as this issue was not raised at the stage of trial. All right?
My lord, in the statement we have raised,
You have raised the statement at the stage of trial,
pleading was there.
in the pleading,
Yes, in the written statement.
in the written statement.
That he is the
Okay, would you like
necessary
to
party. The court did not consider, my lord.
So you tell me how to dismiss this argument.
161 is for Electricity Act within that lordship, service lordship. This is not applicable in case of lordship, money or all these things. Essential chief electrical inspector, he is to submit submit the report to the concerned authority, not the court. So this is not applicable at all.
Well, he has been authorized with the powers of a civil court member.
Yes.
Otherwise, he has been authorized. So he can call for witnesses, call for the record.
Yes, this is another subject matter within the ambit of the electricity act.
The learned counsel for the respondent has, however, raised objection stating that the non-compliance of 161 of the Act is not relevant to this case. As to this case, which is a money suit brought up against the appellants. A line to in the wake of the foregoing discussion, this court is hesitant to interfere with the appeal. Full stop. Appeal is hereby dismissed. No order as to cause. Send back the trial court records. We have the trial court records, no?
Yeah.
Yes, I have just gone. There will be a tweaking here and there. Tinkering here and there. Oh, I to in the in terms of the observation made in terms of the observation made in the RFA 8 of 2021, I stands. You can take the gazette back.
Yeah.
Anyway, your argument was a good argument.
Hello,
Yes.
sorry, because I could not contact him because it's very remote.
It's
Anyhow,
okay.
tomorrow I'm going to my
We'll
place.
fix a
I'll
date
confirm
then.
next week.
Yes.
And regarding that judgment, Miller Bhaskar, that's judgment. Please, your lordship is correct because it was review was there.
Huh?
There is a review.
Yes.
Review by Renudas, by wife. That is got dismissed.
Oh.
Meaning there were this Bhaskar Das cases, judgment is standstill. Review is dismissed. It's not going to any other.
Review is dismissed.
Review dismissed.
Okay, so not overturned.
No, not overturned. That is. No, this will discuss on, but above all, it is this one. These all 3 points were taken. Here, only 3, your lordship was 3 grounds it was there. 498A, criminal this one. This is also, these are all things been discussed. There's lastly amounting to cruelty. It has been decided by
Something, but I forgot exactly. So
No,
there was
anyhow,
something
Millard.
So we'll give you a date.
Great, Millard. I'll also go tomorrow.
Yes.
My place so that we can discuss also. It is very crucial, Millard, for running the case after years, 3 years, 4 years. Suddenly it is, I advise my learned friend also. You also get proper instruction.
Yes. Okay.
Next week or 10 days.
Learned Counsel Mr. Samua
C. Borua.
C. Borua is present and Learned Counsel Ms. MJ for appellant or for respondent. List the matter on. K number case है तो मी जो है मीने को
Hearing day. Brother, it is hearing day. Is it hearing day? Oh yes. Oblige you.
দুটা হে আছে আৰু এতিয়া তুমিয়ে কৰি পেলা দুটা হে আছে না মিনিং মাতি দিয়া নহলে
এইটো দিম নেকি লাগিব is it required?
No, we'll take it up on the next
Yes, review petition number. You made the note down. 73 of 2020.
You keep it with you, we'll take it
Yes,
up.
yes. Oblige.
I wouldn't be able to take up 2 judgments I have given, 2 arguments I have heard. So I think I am saturated on my head.
That means that it will be fixed after view vacation.
List this matter on view vacation official media.
No.
Parties are represented. List this matter on
24th, we have a fixed item. 29. 29 April.
নালাগে 17 আছে বাকি এটাই আছে I won't be able to take up.
More, my lord. Date may be fixed, my lord.
Are you ready?
My lord, today we are not ready, but otherwise,
Thank God. I won't be able to take up also today.
it's a big matter, my lord. There are lots of documents to issue.
Because I have taken up two matters. One I have already dictated judgment here, and then one I'll be dictating now. So, okay. Parties are represented. List this matter. When do you want?
But, March last week.
April?
24th. मतलब 4th of April. Senior.
It's a Friday,
Or
not a hearing day.
third, my lord, third.
Further, there are too many cases. Then comes the Bihu holidays.
8 April.
না হেৰি বিহু তেতিয়া নাহে নহয় বিহু আৰু এটা সপ্তাহ আছেতো পাছত
Motion will be a motion week. Before vacation it will be a motion
yes
week.
yes
22nd. Public.
19 এটা আছে নেকি at night appearance are not present
Appellant is
Sunday free আছে
Your Lordship will find, my lord, we are plaintiff in the suit, and both the court below has held that the claim of the plaintiff is justified, reasoned, and accordingly decree was passed.
this is RSA
This is RSA.
RSA is there any stay
There is stay, Your Honor.
Oh.
That's why
that's
Your
why they are
Honor.
not present
Yes,
that is why they are not present
that is why they are not. Both the court below has held, Your Honor,
yes
my lord, that
we
they are
give them
fun-
one last chance if they don't turn up then if issues have been questions of law have been framed we'll decide it
My lord.
whether there are questions of law or not
my lord, concurrent finding of fact. Both
yes
the
yes
court,
absolutely
both the court below has.
we'll give them one last opportunity must always give them one last appellants are not represented today learned counsel Mr. B.K. Sen is present for the respondent this matter positively for hearing on the next day failing which necessary order please this matter positively for hearing on 22nd April na ki kola 22nd April failing which necessary orders will be passed
I'm deeply obliged.
21 and 22 কেতিয়া দিলে আৰু হয় নেকি এইটো অথনি কিবা এটা লৈ গৈছে নেকি চাপ্লি ফাইলটো মোৰ ওচৰত নাই কিবা এটা ডেট চেট লৈ গৈছে yes
May please the Lordship. Lordship, in the previous petition, there was a order passed by the Honorable Supreme that there is a stay operating in this matter, and Lordship, the present dispute is pertaining to whether a penal damage, whether a penalty can be imposed without issuing any kind of a super.
you have submitted argument last time
Lordship, not a written argument. Lordship, in the previous occasion, previous repeated occasions, the appellant has been seeking adjournments in this matter. And Lordship, there is a previous order passed by Honorable Justice Bobby Goswami in this matter that the
okay
Union of
there's a appeal pending in the Supreme Court
Yes, my lord. Yes, my lord. In regard
similar
to that.
matter
Yes, my lord.
but they are not present here today
Exactly, my lord, because there is a stay pending, and Lordship, your Lordship, in the previous occasion, considered that the stay will be vacated and the appeal will be disposed of because of this fact. Because Lordship, in the previous occasion, in this matter only, Justice Bobby Goswami has observed that
I understand
if the railway failed to obtain any kind of a stay
I have seen my last
till 25th January. Lordship, this is the status
status of the previous last date in which the matter was listed before the Supreme Court, and the petitioner has sought adjournment before the Supreme Court.
If the K. Gogoi is held up in court number 12, I think informed. Is it a matter?
We will fix it for another date because now it's 3 p.m. and it will take some time if the matter is heard.
Yes, Lordship,
will
there
take
is
some
an
time.
admitted matter and also there is a stay operating. They have clearly admitted fact
No,
that
no,
they have not issued show cause.
let him come. He is busy in another court.
Yes, Lordship, I'm not saying Lordship should dispose of right away. I'm saying Lordship a short date may be granted
yes.
and matter may be listed in the top of the list because Lordship, there is a clear admission of the fact that respondents, they have itself admitted the fact that they have not issued any kind of a show cause notice. And the law is very much settled that the show cause notice is a mandatory prerequisite. That's the Lordship, in light of Order 12 Rule 6, Lordship.
Learned counsel for the appellant, what is his name?
K. Gogoi, madam. K. Gogoi
K. Gogoi is in another court. Learned counsel, Mr.
D. Rathi.
D. Rathi is present for the respondents. List this matter on data DTA.
Lordship, there is one another small thing in this cement manufacturing co. Lordship,
Well, I am for the appellant, my lord.
in cement manufacturing co. Lordship, it's item number 20.
Okay.
Connected matter. Both are connected.
Connected.
Matter. Yes, madam.
Yes.
Lordship, it may be disposed of then today itself.
My lord, it may be fixed, my lord. Another date may be fixed.
Lordship,
Learned counsel for the appellant has Mr. It would number 2
G. Goswami.
G.
G. Goswami.
G. Goswami has paid for adjournment. Learned counsel for the respondent, Mr. D. Rathi, has raised for the interest of justice. List this matter for hearing positively on.
Lordship, on 13th March itself, similar nature matter has already been listed.
13 March?
13th.
No.
Lordship, already.
I won't be able to hear on 13 March. Too many cases fixed on 13 March.
Lordship, in a short, next week, 18 March, it may be listed because.
No,
It
not
is
not
2015 April,
not in the month of March. On April only. 3rd April.
Lordship, there is just one small thing. In the cement manufacturing co, the name of the company has changed. The cement manufacturing co has been changed to Star Cement now, Lordship. Lordship may kindly permit me to make the necessary.
Yes.
My lord, actually, for this, my lord, riskiest for my lord, change of name, my lord, because from the tribunal itself, my lord, the name is my lord senior manufacturing company. Now it is changed, my lord.
Lordship, in this
They
date,
can amend by
hand, my lord, it
giving
cannot.
two names or
Yes.
At the rate.
Yes, Lordship, at the rate.
Also known as. They can amend it by giving two names, but you will have to amend it.
Yes, Lordship, I'll do that. Much obliged, deeply obliged.